Now, the Reverend Jesse Jackson in town today to take on Georgia's Stand Your Ground law. His organization is filing a lawsuit against the governor and the attorney general. Lawyers for the Rainbow Push Coalition said the suit is targeting how the law is applied. They say some people can use it to get away with murder, but others can't. Story number 9, fair to say this is a hot button topic here in Georgia, across the country, of course, as well. Jeff Hollinger joining us now with both sides of this interesting debate. Jeff?
Hey, Melissa, thank you. Joining me now to talk about this issue is Robert Patillo, an attorney with Rainbow Push Coalition. That's a civil rights group founded by the Reverend Jackson, and John Monroe, an attorney with Georgia Carry, a guns rights organization. John, let's begin with you. Does race make a difference in Stand Your Ground, do you think?
Well, it doesn't on paper. If there have been allegations that the law is applied unevenly across races, which may or may not be true, I don't know. But just because the law is applied unfairly doesn't make the law itself unconstitutional.
Same question to you, Robert. What about race in this?
It absolutely is an issue. And what we have to understand that the law has to apply equally to all individuals, regardless of race, sex, age, national origin, any other criteria. There's not one speed limit for 25-year-old African-American males and a different speed limit for 80-year-old white women. But I can't think of any factual context in which a 25-year-old African-American could claim a stand your ground defense against an 80-year-old white grandmother.
Now, you're not going to get this overturned in any of these state houses right now. So you believe that you have a loophole. Is this more about public relations trying to draw attention to this, or do you have a legitimate chance legally to get this thing overturned?
There absolutely is a legitimate chance. You have to realize that the Stand Your Ground law abrogates the constitutional protections of equal protection and also of due process by not apprising people what the exact parameters of the law are. By making life or death decisions based on someone's quote-unquote reasonable belief, we believe that this violates the Constitution, and we have a great chance in court.
John, we're a little further down the line now on this case, on this law. How do you think it's done so far?
Well, it's been the law in Georgia since before Georgia was a state in 1776. It was the law when Georgia was a colony. It's always been that case. It's always been the law here. Nothing's changed. The statute in 2006 only codified the existing common law.
You don't think it's ambiguous at all? In other words, if you and I are fighting over a parking spot outside, you cut in front of me, I don't like it, I get out of it, I'm bigger than you are, and I'm shouting an obscenity, do you have the right to take my life?
Well, everything has to be decided on a case-by-case factual basis.
And is a judge capable of determining what intent is?
Well, that's what judges are charged with doing every single day in courtrooms all across the state and the country.
You think judges are capable of that?
Absolutely not. What we have seen from the families that are plaintiffs in this case, the family of Herman Smith, the family of James Christopher Johnson, is individuals do not know the parameters of the law until after the event has taken place. We don't have a law where you find out the speed limit after you've already been arrested. And that's what Stand Your Ground does. You don't find out if your activity, if your action was legal or illegal until after it's already taken place.
All right, I've got seconds left. 5 years from today, where do we stand on this? Robert, give me a brief answer.
I absolutely believe the case will be, the law will be overturned by the court system, and we'll have a new self-defense law in
John,
Georgia.
5 years from now, where are we?
Exactly where we are now. Even if the statute were overturned, we'd be exactly where we were before the statute was passed, because nothing changed.
John and Robert, thanks for coming in tonight. Have a great weekend. We appreciate it.